Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. There is a concept of parental manipulation that the court is always trying to pierce in order to get to the truth of something. The court does not like to see that children are being manipulated to do something or to say something in court in an effort for one parent to jockey for position in the custody battle. So it's really something that what the court wants to do is ensure original and accurate testimony from all the parties. If the court wants to take testimony from children regarding the issues of custody, the court doesn't want them manipulated by threats or by gifts or some other means. So the court is going to take that very seriously. It is, of course, a little problematic. How does one prove that the child is being manipulated to say, I'd rather go with mom? How do you prove that? Well, there are ways to prove it. I mean, we've seen cases like this where dad finds out that mom tells the child. If the child testifies that dad's no good and he wants to go with mom, mom's going to buy the kid a car when he's 16. Mom's going to do something that will be, in the sense, bribe the child for the child's vote, so to speak. If the court finds that out, you can well expect that you're probably not going to get custody. The court's going to find that that level of manipulation is horrific and it really shows no regard for the child. Really shows more of a regard for winning than for what's in the best interest of the child, so you got to watch for that. Another way you might be able to prove it is by the language that the child uses in testimony. So, for example, if you can demonstrate to the court, and we've done this before, where the child will get up and say something very sophisticated, something very unique. And what we've done is we've taken old reports from the child's most recent school year, for example, reports that the child wrote in his own words, and we've demonstrated to the court how the child normally communicates. And then all of a sudden come to court, he's all speaking in this sophisticated language and talking about how dad is a gaslighter and dad is opportunistic and he's a narcissistic person and all this. The key language that people seem to be just throwing around nowadays. If the court gets the sense that words were put in the mouth of the child, the court is not likely to give that testimony a whole lot of weight. In fact, you might well be able to show that those words that the child spoke were not actually original, but were fed to him by the dad or by the mom. And like I said, you could do that by showing the normal vernacular that the child uses. You could certainly do it that way to show that the child's being coached. So here's my point. A smart lawyer is going to be able to figure out that the child is being coached and how to demonstrate it to the court. It's not a good idea, okay? Remember that the express preference of the minor child is only one of 12 factors. It's not likely to carry the day, given the other 11 factors. So my suggestion is don't try to manipulate your child into testifying one way or another. Don't promise your kid a bunch of things because it's going to backfire on you. Even if you intended to give it anyway, I would hold off on making any representations until the custody is determined. Because anything you give, let's say it was a big birthday, you were going to do it anyway. Let's say you and your ex planned that when the child turns 16, we're buying him this car, and you bought the car. And then afterward, the divorce came up. So you never gave him the car. Even you're saying, okay, it's April now, in July we will give you the car that we actually said we were going to. That's going to come out looking like a manipulation. You need to hold off on all of that until the court makes its rulings. And then you can do whatever you want. But if you're going to do something that's going to look like you're, in essence, buying testimony with some sort of manipulation, it's going to play very poorly before the court. If you have any questions about that, reach out and we'll be glad to help you out.